effectively new evidence. And we'll get into this in more detail in a moment. New evidence that militates and warrants and justifies a new trial. The second track is a petition for clemency that the Menendezes have taken directly to Governor Newsom. Governor Newsom has the constitutional power, and it's unilateral, to grant that petition of clemency and commute the Menendezes' case and release them immediately. He has that power today. He's had that power since 2019. He can exercise it. However, he has no deadline. There's no court hearing, and there's no appeal from his exercise of that power. And the third track is a track called resentencing. Resentencing is a somewhat California notion. There's not too many states that have a resentencing statute. The resentencing gets triggered by a district attorney's motion, or in some circumstances, the motion of a court. And that motion, unlike a habeas motion, where a habeas motion will focus on the trial itself, a resentencing motion focuses on that trial but goes beyond that and deals with rehabilitation and other factors. Today, we're going to focus in two different things. The first is, in order to explain the procedures that the Menendez case has gone through, we have created a video that can be accessed at our website, which is da.lacounty.gov. Again, that's da.lacounty.gov. And that video actually does an anatomy of the Menendez case. And it takes the case from the murders itself back on August 20th of 1989 through the investigation into the charges that were filed in the arrests. Then it looks at the motions that were filed by the Menendezes prior to the trials. Then it looks at the first trial, which resulted in hung juries. Then the second trial, which resulted in convictions for first-degree murder of both Jose Menendez, the father, and a separate first-degree murder conviction for Kitty Menendez, the mother, as well as a conviction for conspiracy to commit murder and certain special circumstances allegations of lying in wait and multiple murders. That video then continues on, though. It goes through the penalty phase, where the Menendezes were either facing the death penalty or life without the possibility of parole as determined by a jury. Then the sentencing. Then it actually goes through the various appeals, the direct appeals, all the way up to the California Supreme Court. The first habeas petition, again, with the California Supreme Court. The federal habeas petitions with a U.S. District Court and a Ninth Circuit Court of Appeals. In all those situations, as you will hear, the Menendezes have raised many of the same exact arguments that they raised in the current habeas petition. Those arguments have been heard by a variety of courts, from the trial judge to the direct appeal Court of Appeals in California Supreme Court, to the California Supreme Court again, to the federal courts. They've considered these arguments, and they have been routinely and repeatedly rejected. So we have the video that is coming out and go through this procedural history so that people can actually learn from the Menendez case and help and actually educate themselves on the criminal justice system. What I have said very often is, if the Menendez case is the portal by which people come into the criminal justice system and show an interest in it to find out what's happening, then hopefully they will educate them further about what happened not just in the Menendez case, but cases, criminal cases, that are occurring throughout this entire county, this state, and this country every single day. So the video is coming out today, and it'll be out on our website. The second thing that we have done today is that we have filed an informal response in connection with the habeas motion. As I mentioned before, there are these three parallel tracks: the habeas, the clemency, the resentencing. Again, the clemency is up to the governor. Resentencing we will be dealing with in the future, in the next coming weeks, with our response. But today we have filed the informal response on the habeas petition. Now, something you need to know about a habeas petition: it's not the direct appeal. The Menendezes have already had their direct appeal through the California Court of Appeals and California Supreme Court, and they have lost. They've even had one level of California habeas, which they lost, and one level of federal habeas, which they've also lost. So now they've come back for a second California habeas petition. And in coming back for that, they have basically said there are two new pieces of evidence, along with their arguments, that justify them getting a new trial. Now, in a habeas petition, there are very rigorous requirements to actually get that new trial, which makes sense because you've already gone through all these different layers of review. And if you've been rejected time and time again, at some point the system says that unless you have something very new and very compelling that is more likely to change the outcome of this case, then we are going to again reject your habeas petition. So when they come out in this case, they come out with two new pieces of evidence. One piece being an undated photocopy of a letter purportedly sent by Eric Menendez to his cousin Andy Cano at approximately December 1988, although there's no date on the letter, in which it discusses sexual abuse that was being experienced by Eric, perpetrated against him by his father at that time. That's the one piece of evidence that they've come forward, but they also came forward with a second piece of allegedly new evidence. The second piece of new evidence was a declaration by Roy Rossello, who basically said that in the early 1980s, he had been sexually abused by Jose Menendez. But the standard to actually have a successful habeas petition requires that you meet all of the following requirements. You have to show that it's new evidence. You have to show that it's timely, that it was evidence that could not be discovered at the time of the trial, but only could be discovered after the trial. You have to show that you did not engage in any substantial delay between the time you learned about the evidence and the time you brought your motion. The evidence has to be admissible, and the evidence has to be credible. Now, the overall argument about this new evidence, again, new evidence effectively dealing with sexual abuse that Eric Menendez experienced by his father, or a gentleman named Roy Rossello experienced by Jose Menendez, the defense has now argued the following. They've said to resolve this case, jurors had to decide a single critical question. Was Jose Menendez molesting his sons? The problem with saying that that is the critical question in the Menendez trial is that it's wrong. The jury never, in any of the two juries, had to resolve the question of whether the Menendez brothers were sexually molested. In fact, the counsel, Leslie Abrahamson, 30 years before, during these trials, properly framed where sexual abuse comes into play. What she said back then is that we have never said that because you're abused, you're justified in killing your abuser. We didn't argue that, and we never will. Well, 30 years later, apparently, the Menendez counsel is arguing just that. Because what the jury had to figure out is on the night of August 20th, 1989, did the Menendezes conspire to kill both their father and their mother that night? Did they, in fact, kill them? And what was their state of mind at that time, on the night of August 20th, 1989? Did they engage in these killings willfully, deliberately, and with premeditation, or was it an act of self-defense? They had an actual fear of imminent harm, that both their father and their mother was going to kill them, and they acted in self-defense. The sexual abuse part, as Leslie Abrahamson recognized correctly back then, was not a fourth question for the jury to answer. So when we look now at the factors dealing with this new evidence, we can go through these factors. Timely evidence that is discovered after the trial, for which there is no substantial delay in presenting it. Well, if this letter, supposedly dated December 1988, written by Eric Menendez to Andy Cano, is to be believed, and that it was actually sent at that time, here's what we know. We know that Eric Menendez, during his...
Okay, we're listening to the district attorney in Los Angeles providing an update on the Menendez brothers found guilty of killing their parents back in the 1990s as they seek to get out of prison after spending decades behind bars. The DA there breaking down the different paths to possibly allow them freedom. Of course, that is Eric and Lyle Menendez. We'll keep listening to this press conference and provide any more details about the case if they become available.